Okay, the politics of judicial selection. So picking judges, federal judges, all federal judges are, when needing to be replaced, are nominated by the president, confirmed by the Senate. Michigan judges are elected. Judges are the central participants in the judicial system, and nominating federal judges and Supreme Court justices is a president's opportunity to leave an enduring mark on the American legal system. Guaranteed by the Constitution the right to serve during good behavior, federal judges and justices enjoy, for all practical purposes, lifetime positions. Remember, we did go over they can be impeached. As a result, the average age of U.S. justices is high, and there are typically many justices who are over 75. Life tenure also means that there are fewer changes of justices, try to keep saying that word, than there would be an assistant with shorter terms. Interestingly, every other established democracy provides for some limits on the tenure of judges on its highest constitutional court. Table provides examples. There is discussion, could we change put a constitutional amendment that they serve 20 years? It's talked about. Judges and justices may be removed only by conviction of impeachment, which has occurred a mere 7 times in over 2 centuries. Congress has never removed a Supreme Court justice from office, although it tried but did not convict Samuel Chase in 1805. Nor can Congress reduce the salary of judges, a stipulation that further insulates them from political pressures. So in other words, you can't cut off their pay so that they'll quit. The president's discretion is actually less than it appears, however, since the Senate must confirm each nomination by majority vote. Because the judiciary is a co-equal branch, the upper house of the legislature sees no reason to be especially deferential to the executive's recommendations. Despite what it's going to say, a lot of this gets thrown out because of, in recent times, because of partisanship. There's been, under Trump, the Senate really pushed, it was one of Mitch McConnell's highest agenda items to get as many federal judges in as possible. The lower court, central to the Senate's consideration of state-level federal judicial nominations to the district courts and courts of appeals, is the unwritten tradition of senatorial courtesy. For district positions, so that would be Grand Rapids, Detroit, the Senate does not confirm nominees if they are opposed by a senator of the president's party from the state in which the nominee is to serve. So that wouldn't apply in Michigan. Under Trump, they are both Democrats, but would apply under Biden. For courts of appeals positions, the Senate does not confirm nominees opposed by a senator of the president's party from the state of the nominee's residence. To invoke the right of senatorial courtesy, the relevant senator usually simply states a general reason for opposition. Other senators then honor their colleagues' views and oppose the nomination, regardless of the personal evaluations of the candidate's merits. So if Stabenow or Peters oppose a judge, the other Democrats will give Peters and Stabenow courtesy, senatorial courtesy, and will not approve a nomination. Chances are then it's not even going to get that far. The president's not going to nominate someone typically that their own party isn't going to approve. Because of the strength of this informal practice, presidents usually check carefully with the relevant senator or senators ahead of time to avoid making a nomination that the Senate will not confirm. There you go. Moreover, typically when there's a vacancy for a federal district judgeship, the relevant senator or senators from the state where the judge will serve suggest one or more names to the attorney general and the president. If neither senator is of the president's party, then the party's state congresspersons or other state party leaders may make suggestions. Other interested senators may also try to influence a selection. Another one would be for the Republicans, the Federalist Society, which is an interest group. Federalist Society runs lists of people they want in the judgeships. So I would add an interest group to where they might find names. In early 2009, Senate Republicans added a new element to senatorial courtesy when they sent Obama a letter in which they vowed to prevent the confirmation of judicial nominees in instances where the White House did not properly consult Republican home state senators. The implication of this letter is that members of the opposition party would have a de facto veto power, something without precedent in the history of judicial selection. Obama reached out to Republican senators, but they often refused to make recommendations for the district court, delaying or obstructing the process. Obama was not able to fill court positions in the beginning, and because it was absolutely Mitch McConnell's goal to not have him fill positions, which included, of course, the death of Justice Scalia. Then when Trump came in, that's when they started rapidly filling those positions that they didn't allow Obama to fill. And now we'll see under Biden how that all works out. The White House, the Department of Justice, and the Federal Bureau of Investigation, FBI, conduct competency and background checks on persons suggested for judgeships, and the president usually selects a nominee from those who survive the screening process. Some made it past it, even though arguably they had issues but usually that's the goal. If one of these survivors was recommended by a senator to whom senatorial courtesy is due, it is difficult for the president to reject the recommendation in favor of someone else who survived the process. Thus, senatorial courtesy turns the Constitution on its head, and in effect, the Senate ends up making nominations and the president then approving them. Others have input in judicial selection as well. The Department of Justice may ask sitting judges, usually federal judges, to evaluate prospective nominees. Sitting judges may also initiate recommendations, advancing or retarding someone's chance of being nominated. In addition, candidates for the nomination are often active on their own behalf. They alert the relevant parties that they desire the position and may orchestrate a campaign of support. As one appellate judge observed, people don't just get judgeships without seeking them. And that's well known of the justices on the Supreme Court, that was their goal to get there. I'm not saying all of them, but quite a few of them. The president usually has more influence in the selection of judges to the Federal Court of Appeals than to federal district courts. The decisions of appellate courts are generally more significant than those of lower courts, so the president naturally takes a greater interest in appointing people to these courts. At the same time, individual senators are in a weaker position to determine who the nominee will be because the jurisdiction, remember the right to hear a case, of an appeals court encompasses several states. Although custom and pragmatic politics require that these judgeships be apportioned among the states in a circuit, the president has some discretion in doing this and therefore has a greater role in recruiting appellate judges than in recruiting district court judges. Even here, however, senators of the president's party from the state in which the candidate resides may be able to veto a nomination. Traditionally, the Senate confirmed lower federal court nominations swiftly and unanimously. Normally, it's just procedure. However, the increasing polarization of partisan politics in recent years has affected judicial nominations, especially those for the Court of Appeals. And in modern times, that's been the case for the Supreme Court, but it's getting more and more at the other courts, the district and the circuit courts as well. That's what's really changing. Increasingly, lower court confirmations have become lengthy and contentious proceedings. Many senators use committee hearings to engage in partisan and ideological position taking. Interest groups opposed to nominations have become more active and encourage senators aligned with them to delay and block nominations. As a result, there's been a dramatic increase in the time for confirmation, that was true under Obama. It has actually been very quick under Trump, which in turn has decreased the chances of confirmation. Since 1992, the Senate has confirmed only 60% of nominees to the Court of Appeals. Senators of the opposition party filibustered or otherwise derailed the confirmation of a number of high-profile nominations of Clinton and George W. In response, the president's appointed some judges to the Court of Appeals as recess appointments. Such appointments are unusual and good only for the remainder of the congressional term. After the Republicans newly voted to end the possibility of filibustering judicial nominations, 14 senators from both parties forged a deal that allowed some, but not all, of Bush's stalled judicial nominees to receive floor votes. Nevertheless, conflict over nominations continued as the Republican minority used secret holds, threats of filibusters, and various Senate procedures to delay and often stymie Obama's judicial nominations, even at the district court level. In response, in 2013, the Democrats prevailed in changing the Senate rules to end filibusters for nominations to all but the Supreme Court. And you can't filibuster Supreme Court either now. It's simple majority for approving judges that presidents nominate in order to get these judges through. It's become much more political. And now, at the time of me reading this, the filibuster is also being threatened based on just getting rid of it altogether for regular legislation as well, for these partisan reasons. Okay, so we've talked about picking the district court judges, the appellate or circuit court judges, and now the Supreme Court, which is where most of the attention goes. The president is vitally interested in the Supreme Court because of the importance of its work and is usually intimately involved in recruiting potential justices. Nominations to the court may be a president's most important legacy to the nation. So they'll have a list ready to go in case someone retires in the summer or unfortunately dies. This is a big part of being president, is the Supreme Court. A president cannot have much impact on the court unless there are vacancies to fill. Although on the average there have been an opening on the Supreme Court every 2 years, there's a substantial variance around this mean. FDR had to wait 5 years before he could nominate a justice. In the meantime, he was faced with a court that found much of his New Deal legislation unconstitutional. Carter was never able to nominate a justice. Between 72 and 84, there were only 2 vacancies on the court. Nevertheless, Nixon was able to nominate 4 justices in his first 3 years in office, and Reagan had the opportunity to add 3 new members. I believe Trump added 3 new members. Obama added 2. When the Chief Justice's position is vacant, the president may nominate either someone already on the court or someone from outside to fill the position. Usually, presidents choose the latter, someone outside, to widen their range of options. But if they decide to elevate a sitting associate justice, as Reagan did with Rehnquist in '86, the nominee must go through a new confirmation hearing by the Senate Judiciary Committee. So Rehnquist was already on the court. He replaced, I think, Berger, I think is his name, something like that, off the top of my head. I'm sure it's in here when we go farther. But when Chief Justice Roberts came in, he actually was nominated as a justice and immediately as a Chief Justice. So he started his position, Roberts did, as a Chief Justice. He's never sat otherwise. The president operates under fewer restraints in nominating persons to serve the Supreme Court than in nominations for the lower courts. Although many of the same actors are present in the case of Supreme Court nominations, their influence is typically quite different. The president usually relies on White House aides, the Attorney General, and the Department of Justice to identify and screen candidates for the court. Again, I would say Republicans also use the Federalist Society. Sitting justices often try to influence the nomination of their future colleagues, but presidents feel little obligation to follow their advice. I don't even know if that's true anymore. Senators also play less a role in the recruitment of Supreme Court justices than in the selection of lower court, as the jurisdiction of the court obviously goes beyond individual senator states or regions. Thus, presidents typically consult with senators from the state of residence of a nominee after they have decided whom to select. At this point, senators are unlikely to oppose a nomination because they that is if they're the same political party, remember, because they like having their state receive the honor and are well aware that the president can simply select someone from another state. Although home state senators do not play prominent roles in the selection process for the court, the Senate actively exercises its confirmation power and, through its Judiciary Committee, may probe a nominee's judicial philosophy in great detail. Candidates for nomination usually keep a low profile. They can accomplish little through aggressive politicking. And because of the court's standing, actively pursuing the position might offend those who play important roles in selecting nominees. The American Bar Association Standing Committee on the Federal Judiciary has played a varied but typically modest role at the Supreme Court level. Presidents have not generally been willing to allow the committee to pre-screen candidates before their nominations are announced. George W. Bush chose not to seek its advice at all. Through 2016, there have been 154 nominations to the Supreme Court, and 112 people have served on the court. 4 people were nominated and confirmed twice. 8 declined appointment or died before beginning service on the court, and 29 failed to secure Senate confirmation. Presidents have failed 20% of the time to appoint the nominees of their choice to the court, a percentage much higher than for any other federal position. Okay, recent nominations. For most of the 20th century, which is the 1900s, confirmation of Supreme Court nominees were routine. Only one nominee failed to win confirmation in the first 2/3 of the 20th century, the 1900s. The situation changed beginning in the 60s, tumultuous times that bred ideological conflict. Although JFK had no trouble with his 2 nominations to the court, Byron White and Arthur Goldberg, his successor, Lyndon Johnson, was less fortunate. In the face of strong opposition, John had to withdraw his nomination of Abe Fortas, already serving on the court, to serve as Chief Justice. As a result, by the way, Abe Fortas is the one who did the case for Gideon v. Wainwright in front of the Supreme Court, which we'll probably look at in this class later in the next chapter. The Senate never voted on Homer Thornberry, Johnson's nominee to replace Fortas as an Associate Justice. Nixon, the next president, had 2 nominees in a row rejected after bruising battles in the Senate. 2 of Reagan's nominees proved unsuccessful. In 1987, Reagan nominated Bork to fill the vacancy created by the resignation of Justice Lewis Powell. I was young at that time, but I remember it was a big deal. That made a lot of news. Bork testified before the Senate Judiciary Committee for 23 hours. A wide range of interest groups entered the fray, mostly in opposition to the nominee, whose views they claimed were extremist. In the end, following a bitter floor debate, the Senate rejected the president's nomination by a vote of 42 to 58. So 42 for, 58 opposed. 6 days after the Senate vote on Bork, the president nominated Judge Douglas H. Ginsburg to the High Court. Just 9 days later, however, Ginsburg withdrew his nomination after disclosures that he had used marijuana while a law professor at Harvard. In June 1991, when Associate Justice Thurgood Marshall announced his retirement from the court, President George H.W. Bush announced his nomination of another Black judge, federal appeals judge Clarence Thomas, to replace Marshall. Thomas was a conservative, so this decision was consistent with the Bush administration's emphasis on placing conservative judges on the federal bench. Thomas is still there. He's probably considered one of the most conservative justices on the Supreme Court. Liberals I don't know if liberals were really placed in a dilemma, but this is what the book says. Liberals were placed in a dilemma. On the one hand, they favored a minority group member serving on the nation's highest court, and particularly an African American replacing the court's only African American. On the other hand, Thomas was unlikely to vote the same way as Marshall had voted, and was likely instead to strengthen the conservative trend in the court's decisions. Thurgood Marshall, by the way, was the lawyer who argued Brown v. Board for the NAACP. This ambivalence inhibited spirited opposition to Thomas, who was circumspect about his judicial philosophy, so he didn't really promote it that much, in his appearances before the Senate Judiciary Committee. Thomas's confirmation was nearly derailed. Now, so they say they're ambivalent. I was too young to be able to tell you what the thoughts really were of opposition. I, however, do remember the next part here with Hill, Anita Hill. This was talked about. This is an issue. You add this with Bill Clinton's situation and ongoing discussion about sexual harassment in the workplace, or alleged sexual harassment in the workplace. Thomas's confirmation was nearly derailed, however, by charges of sexual harassment leveled against him by University of Oklahoma law professor Anita Hill. Ultimately, following Hill's testimony and Thomas's denial of the charges, he was confirmed in a 52-48 vote, the closest margin by which a Supreme Court nomination had been confirmed in more than a century. And I believe the Democrats controlled the Senate at this time. No way this person, him being as conservative as he is today, would get through a Senate controlled by the Democrats. Just like I have to wonder if this guy, Ginsburg, would be okay having used marijuana nowadays, if that would not have been a hindrance. President Clinton's two nominees, Ruth Bader Ginsburg and Stephen Breyer, did not cause much controversy and were readily confirmed. As you should remember, Ginsburg died very recently, and Stephen Breyer is still on the court. There is thought that he might retire, though, under Biden. We will see. Similarly, the Senate easily confirmed George W.'s nomination of John Roberts as Chief Justice to succeed Rehnquist. Rehnquist died in office. Indeed, he was not an easy target to oppose. His pleasing and professional demeanor and his disciplined and skilled testimony before the Senate Judicial Committee gave potential opponents little basis for opposition. Ideological conflict returned to the fore, however, when Bush then nominated White House counsel Harriet Miers to replace Justice Sandra Day O'Connor. Sandra Day O'Connor retired. By settling on a loyalist with no experience as a judge and little substantive record on abortion, affirmative action, religion, and other socially divisive issues, the president shied away from a direct confrontation with liberals and, in effect, asked his base on the right to trust him on his nomination. However, many conservatives, having hoped and expected that he would make an unambiguously conservative choice to fulfill their goal of clearly altering the court's balance, were bitterly disappointed and highly critical. They demanded a known conservative. The nomination also smacked of cronyism. That happens. With the president selecting a friend rather than someone of obvious merit, that's opinion, and the comparison with Roberts underscored the thinness of Miers' qualifications. In short order, Miers withdrew from consideration, and the president nominated Samuel Alito. Historically, like the Warren Court, Chief Justice Warren was a governor of California, and I believe it was Eisenhower who promised him that position when it came vacant. And then, of course, Warren became one of the most liberal courts of the U.S. time, and we'll be talking about that next unit. This idea has become now that you pick a judge, someone who's already a judge, so you know exactly what you're getting. Conservatives especially, I assume liberals too, want to know that the judge that gets on the court has already demonstrated strong conservative interpretation of the Constitution. And that's where Miers couldn't make it. She didn't, trust me is not enough from George W. And this is not necessarily how it has to be. It doesn't have to be a judge with a record, but that's what it's become now. Alito was clearly a traditional conservative and had a less impressive public presence than Roberts. Response to him followed party lines, but he appeared too well qualified and unthreatening in his confirmation hearings to justify a filibuster. And without one, his confirmation was assured. The Senate confirmed Alito by a vote of 58-42. Now, if I don't know if it matters anymore if you can't find a reason to not approve. I think the partisanship will be too strong. And that's come down to Obama right here. What happened with Obama has turned the tide on some of this, right or wrong. So here we go. Obama made his first nomination in the court in 2009, selecting Sonia Sotomayor. Although conservatives raised questions about some of her previous statements and decisions, she was confirmed by a vote of 68-31, largely along party lines. Back then, 60 Democrats held the Senate. When she took the oath of office, she became the first Hispanic justice. She's still there. In 2010, the president nominated Elena Kagan, Solicitor General, to the court. She was confirmed by a vote of 63-37, once again, largely along party lines. She's still there. When Justice Antonin, I have a hard time with his first name, Scalia, died in 2016, Senate Republicans announced they would refuse to consider any nomination the president sent to them. Once again, partisanship dominated the process. And of course, as we know, Trump comes in, he puts in, he's had three. There's Kavanaugh, or it was Gorsuch. He immediately nominates Gorsuch. He gets in, and then followed by Kavanaugh, which there was some drama on that one about, you'll have to look that one up. And then, of course, Justice Ruth Bader Ginsburg dies right before the election, and she's a liberal, and they immediately replace her with Barrett before the election. And so given this history, right or wrong, I mean, they have a right to do it, but all of this is leading to more partisanship on choosing judges. It is difficult to predict the politics surrounding future nominations of the court. One prediction seems safe, however, as long as Americans are polarized around social issues, and as long as the court makes critical decisions about these issues, the potential for conflict over the president's nominations is always present. As this chapter's "You Are the Policy" debate makes clear, the conflict over presidential nominations to the Supreme Court can have repercussions not just for the votes that members of Congress cast during confirmation hearings, but for their very willingness of Congress even to hold hearings on nominees in the first place, which is what they didn't do for Obama. Nominations are most likely to run into trouble under certain conditions. Presidents whose parties are in the minority in the Senate, that would have been Obama, or who make a nomination at the end of their terms, face a greatly increased probability of substantial opposition. That's Obama's a good example of that. Presidents whose views are more distant from the norm in the Senate, or who are appointing a person who might alter the balance of the court, are also likely to face opposition. I don't think that matters as much anymore. It's politics at this. It's Republican versus Democrat. However, opponents of a nomination usually must be able to question a nominee's legal competence or ethics in order to defeat the nomination. I don't even think that's true anymore. On the test, I believe this is asked. You don't go after a justice or and say, we are not going to approve this nomination because he's too liberal or he's too conservative, or she's too liberal, she's too conservative. You have to find another reason. You have to find something in their morality or in their past. That's the traditional understanding. I don't know if that matters anymore. I don't even know if you have to give an opinion. If your majority party is the opposite of, if the majority party of the president is the opposite of the president, they're just probably most likely going to not hear or not approve the nomination. But we'll see. This might not be the case in the future, but it's where it's headed right now. However, opponents question competence. I think most people do not consider opposition to a nominee's ideology a valid reason to vote against confirmation. I don't know if that's true anymore. For example, liberals disagreed strongly with the views of Rehnquist, but he was easily confirmed as Chief Justice. That was back in the 70s and 80s. By raising questions about competence or ethics, opponents are able to attract moderate senators to their side and to make ideological protests seem less partisan. I will stop here and pick up at backgrounds of judges and justices.